Our biggest concern from a compliance standpoint lies in the heart of California Labor Code Section 351. In that section, the law specifically states that tips belong to the employees. It is their property, not the employers, not the companies in any way. Rather, it's their obligation to make sure that all of those tips are properly reported, that taxes are paid, and that at the end of the day, that they are claiming that income as part of their annual wages paid. And the problems that we're running into more often than not is this. Employers simply are not getting it right when they report on the payroll stubs of their employees how those wages were earned. Many restaurants still classify tips as wages on their pay stubs. That is not accurate. It needs to be a separate line item that is separately tracked, that shows the taxes, withholdings, and deductions from each individual source of revenue. This is specifically laid out in California Labor Code Section 226A that requires every employer to provide accurate pay stubs to every employee every single pay period. And if you make a mistake and you improperly report those tips, that's where penalties come into play. And penalties are expensive and they cap on top of each other. Penalties start at $50 per pay period per employee, and they go up to $100 per pay period per employee with a maximum penalty of $4,000. Not to mention the attorney's fees that get tacked on top of that. If an employee recovers even $1 in penalties, they are entitled to all of their attorney's fees to be recovered as part of that award. So when you think about how many employees you have, $4,000 times the number of employees can be a huge, hefty penalty if you aren't getting this correct.